Hi everyone, I'm Sabrina, a lawyer at Verity Law. Joining me today is Tina Lee, founder and experienced employment lawyer at Lee Workplace Law.
Hi everybody, thank you for inviting me, Sabrina.
Of course. In the past 7 years, we have helped countless entrepreneurs with their business needs. We discovered that many people are good at their craft, so they make a lot of money. But at the same time, because they're not familiar with the law, they also end up losing a lot of money. Today, we will teach everyone how to avoid common pitfalls and reduce your risk.
Sounds good. Let's start with directors and shareholders.
All right. When you register a limited liability corporation, you must choose at least one director and one shareholder. Shareholders are the owners or investors of the corporation. Their information is often kept private and only recorded in the company's internal document called corporate minute book. In contrast, directors are the managers of the corporation, and their identity is recorded on the articles of incorporation and corporate notices. Those are public documents that can be looked up by any business lawyer.
Makes sense. I know many people think that if you are a majority shareholder, then you would be the person liable if something goes wrong with a company.
Yeah, many people think so, but that is wrong. The whole point of registering a limited liability corporation is so that the company itself, and not the individual within it, is the one liable. That means that in most cases, if the company gets sued, then it is only the company's bank assets and accounts that can be taken away. The directors' and shareholders' personal assets, like their house and personal bank accounts, are safe. This is the case even if there's only one director and shareholder to the corporation.
Of course, there are some exceptions. Owing employee wages could result in the directors facing personal liability and potentially putting their personal assets at risk.
Exactly. But when that happens, the one at risk is the director, being the manager of the company, and not the shareholder, being the passive investor to the company. So Tina, what are some common reasons why employees sue their employers?
One common reason could be to do with working hours and overtime. According to the Employment Standards Act in Ontario, most full-time employees can only be required to work up to 8 hours a day and 48 hours a week. There are some exceptions to certain specialized industries and professions. Also, the employee must be given at least 30 minutes of break time in a day, although this break time can be unpaid.
Makes sense. But how would the employer and employee record their hours? I know this is especially hard when the employees are working at home.
Employers could require employees to log their starting and end times manually and submit timesheets or using a software.
Sounds good. Now, many entrepreneurs ask me, if the employer and employee signed a contract that will allow more working hours, is that legal?
It could be legal, provided that the contract is properly written, and in most cases, the total weekly work time still does not exceed 48 hours, except for limited exceptions. So as an example, within a week, an employee could work 10 hours on Monday, but 6 hours on Tuesday.
Oh, that makes sense. But I know that most employees, no matter how hardworking, would require a rest.
For sure. So the law is that within a 24-hour day, the employee must have at least 11 hours during which they're not working. Also within a week, the employee must have at least one full day or 24 hours of rest time.
That's reasonable. A 7 days work week is not sustainable.
Yes, and even if the employee needs to do overtime here and there, the company must ensure that for every 2 weeks, the employee has at least 2 days of consecutive rest time.
Understood. Now, how is overtime pay calculated?
When an eligible employee works more than 44 hours in a week, they would be entitled to overtime compensation.
And how much is the compensation?
For overtime pay, it is 1.5 times the employee's normal salary.
All right. Now, what if the employee agrees to having more time off instead?
That's a good question. Then instead of overtime pay, the employee can get more paid time off. This extra paid time off must be used in 3 months. However, this time can be extended to 12 months if both parties sign a contract stating that clearly. Also, the paid time is 1.5 times longer than the normal paid time off. So as an example, if an employee worked the equivalent of 10 business days, they would be entitled to 15 additional business days off paid.
Understood. Most employers complain that they did not authorize the employees to work overtime. The employees decided to do overtime themselves and then sue for the overtime pay. Is this legal?
It could be valid as long as the employee could prove that they indeed worked the overtime hours, then they could claim overtime compensation. So to counter this, we recommend that employers have a proper administration process within the company to monitor the employee's hours. As well, in the employment contract, the employer can benefit from stipulations. For example, employees must obtain advance written approval before working any overtime hours.
Now that's a good solution. I know that when an employee wants to sue their employer, they don't necessarily need to hire a lawyer. Is that right?
That's correct. They could file a complaint with the Ministry of Labor on their own. An officer is then typically assigned to investigate and make findings. If the officer finds the employer to be at fault, then they could require the employer to pay compensation to the employee, or they could order reinstatement or pay a fine.
All of these rulings are pretty severe. All the business owners must be careful.
That's really true. The best way is for the employer to have a reputable employment lawyer supporting their work and understand how the law works. There are some offenses that could result in up to $100,000 of fines, even with the first offense. In May of this year, 2024, the Ontario legislature introduced new updates to the Employment Standards Act. And one notable update is that employers could be fined up to $100,000, and that was up from $50,000 in the past.
My word. What are some situations in which the employers can be fined that much?
One common example is if an employee decides to take a job-protected leave of absence from work, such as a maternity leave, and are penalized as a result. This is especially severe if it's not the employer's first offense.
Oh, I see. But we also have some good news. If the employer consulted a labor lawyer and had a comprehensive employment agreement and a good management system, then they're protected from employee complaint.
Yes, if the employer is generally compliant, then a frivolous complaint could be resolved without too much difficulty. So it is important to be familiar with the law. One thing to note is that if the legal proceeding is in court instead of with the Ministry of Labor, then often the losing party may have to pay part of the successful party's legal fees, which could be anywhere from 40% to 70% of the legal fees.
I see. I know that some employment lawyers also take cases on contingency fee basis, right? That means instead of billable hours, they only charge legal fees if they win the case.
That's correct. Some law firms do charge on contingency, and in that case, the fee structure must clearly be explained in the retainer agreement signed by the client.
Understood. We mentioned earlier that employees can hold the directors personally liable, even if the company goes bankrupt. But what if the directors resign from the company? Would they be safe then?
Not necessarily. If the director held directorship during the time that the employee was owed wages, then the director may still be held personally liable.
Makes sense. I've seen many directors who decide to leave the company after they receive a notice from the Ministry of Labor. That is not useful.
Correct. The best practice, as mentioned, is to ensure that you're familiar with the law and the company stays compliant during the term of the directorship.
For sure. Also, when there are multiple directors, they must clearly monitor each other's actions. The employee is not limited to suing the one director that hired them. They can sue any directors who are in office during the time of the worker's employment. So if any directors discover that one director is going rogue and hiring people without the other's agreement, they must stop that director.
How can they stop this?
Well, the shareholders can vote the rogue director out of office. This must be a majority vote. The best way is to look at the internal corporate documents and see what constitutes as a majority vote. If there are no such documents, then they will have to rely on the legislation.
That makes sense. What if it's the opposite though? What if most directors decide not to pay an employee's salary on time, but one director disagrees and wants to stay compliant?
That's a difficult situation. Then that director should immediately resign. Most people think that only with shareholder approval can a director resign. That is not true. When a director chooses to leave, it's similar to when an employee wants to quit. The director does not need anyone's consent to quit. They can just send a formal letter to the company and have their business lawyer update the government's website listing who are the directors.
And as a reminder, any lawyer can look up who the directors are to any Canadian corporation.
Yes. So the notice to government must be done immediately after the director resigns. That way, it is a notice to the public that this director who quit is no longer responsible for the company.
Right. And once again, this must be done before the legal issue arises, not after.
That's true. Okay, it's time for a summary. In most cases, when a limited liability corporation gets sued, only the company's assets are at risk. The directors' and shareholders' assets are safe.
There are some exceptions to this rule, including when the company owes the employee wages. In those cases, the employees could sue the directors for personal liability and, if successful, enforce on personal assets. As we discussed earlier, this applies when wages are owing.
All right, that is all for today. Thank you, Tina, for joining us. We will see you in our next month's video.
Thank you.